This video, we're going to talk about how the IRS has certain authority to grant equitable relief under Internal Revenue Code 6015F for a spouse who requests innocent spouse relief from an unfair tax burden. Now, there are three different ways that the IRS might be able to grant innocent spouse relief. There is Internal Revenue Code section 6015B, innocent spouse relief. There is section 6015C, and finally 6015F, which is equitable relief. Equitable relief is granted in cases where the IRS is able to determine that it would not be fair to hold the spouse liable for an understatement or underpayment of a tax when other relief provisions do not apply. Basically, if the spouse does not qualify for relief under one of the other sections, then the IRS would go through its protocol under 6015F to see if it can grant the requesting spouse equitable relief. Under the tax law, this is the only statute that gives the IRS permission to grant relief from underpayment of tax. The other two sections talk about understatement of tax. For example, if a spouse misrepresented a tax position on a tax return, and during an IRS audit, it was determined that there was an underpayment due to that understatement, then one of the other code sections might apply to granting relief. However, this is the only section in which the IRS can grant relief in a case where it's already been determined that there is a tax and the spouse that is not requesting relief should be held responsible and is simply not paying the tax that's applying to both spouses. And in 2013, the IRS came up with Revenue Procedure 2013-34. It's a 32-page document that discusses the guidelines for considering equitable relief under this code section. However, we can go through this part of the Internal Revenue Manual and just understand some of the factors that the IRS will be considering when they take a look at your request. So, as I previously mentioned, this code section applies to understatements as well as underpayments, and this is the only code section where there is relief for underpayments. There are 7 threshold conditions which must be met in order for the IRS to grant relief. So we're going to go to those sections right now. So the 7 conditions are: there must be a joint tax return filed for the year in which the relief is requested. One of the other code sections does not authorize the IRS to grant relief. And furthermore, there is no relief available under community property law, Internal Revenue Code section 66C, that relates to taxpayers filing separate returns in community property states. So this is a last resort type option. 3, the individual must have requested relief within a time period that the collection statute or refund statute remains open. So any request for equitable relief may be made with respect to any tax liability that has been paid if that request is made during the period in which the individual could submit a timely claim for refund of such payment. No fraudulent transfers. So if the IRS determines that assets were shuffled around between spouses as part of a scheme to defraud the IRS, you will not see relief granted under that situation. They cannot be transfers of disqualified assets. We'll discuss that in a little bit more depth, but same intent. If you're shuffling assets around to try and trick the IRS, then equitable relief will not be granted. If you, as the requesting spouse, did not knowingly participate in the filing of a fraudulent tax return, you can seek relief. But if you had any participation in the filing of a fraudulent return, then you'll be subject to penalties of fraudulent returns, and you will not be able to seek relief. And then finally, the last qualification is that the liability has to be at least partially attributable, if not completely attributable, to the other spouse, the non-requesting spouse. So if there's liability that's attributable to both spouses, then the equitable relief will only be considered for the part that the IRS deems to be attributable to the non-filing spouse. There is an opportunity for the IRS to issue a streamlined determination, which kind of speeds up the process. So if all of these threshold requirements are met, then the IRS can grant relief in a faster manner. So if they are not married, if the requesting spouse is no longer married to the non-requesting spouse, if the requesting spouse can prove that economic hardship will result if relief is not granted, and if the requesting spouse did not know or did not have a reason to know of the understatement, or if the IRS determines that the non-requesting spouse will not or cannot pay the underpayment of tax, then the IRS can grant relief in a much more streamlined fashion. So here are some of the factors that the IRS will consider. We'll go through them in a little bit more depth, but marital status, economic hardship, knowledge or reason to know, legal obligation, a significant benefit, and compliance with income tax laws, and mental and physical health. Abuse or financial control is not a standalone factor. However, the IRS Form 8857 does have certain sections that ask questions about whether or not abuse is a factor, and it is a consideration that's explained in much more depth in Revenue Procedure 2013-34. So it is a consideration even if it's not a standalone factor. So marital status. All of these factors have weights in favor of relief, neutral weights, or weights against relief. So if the requesting spouse is divorced, legally separated, a widow or widower to the non-requesting spouse, and is not an heir to the non-requesting spouse's estate, which would have enough assets to pay the tax bill, or if they have not shared the same household at any point during the previous 12 months, then any of those factors would help the IRS determine in favor of relief. If they're still married, or if the requesting spouse is a widow or widower and an heir to the estate, and there's enough assets in the estate, then this is a neutral factor, meaning that it doesn't go against or for approval. It simply is just recognized, and further evaluation on other factors is required. Economic hardship. If the IRS can determine that denying relief would cause economic hardship, then this would weigh in favor of relief. If this would not cause hardship, or if the requesting spouse is deceased, then this is a neutral factor. So the rest of this part of the manual goes step by step in helping an examiner determine what economic hardship looks like. But we can go over that. If gross income is at 250% for the size of the family or less of the federal poverty level, and the requesting spouse does not have assets where that can make the liability payments, you don't need to look at expenses. However, if they can determine that the gross income is at or below 250% of the poverty level, if the gross income is more than 250% of the poverty level, but the income minus expenses is $300 or less, then that could be considered an economic hardship. And you can Google federal poverty guidelines to see what the federal poverty level chart would look like for your state in the year that you're looking at this and for your family size. Knowledge or reason to know. So in favor of relief, if you can determine that you did not know and you did not have reason to know of this item that caused the understatement or deficiency, or if you had a reasonable expectation that your other spouse would actually pay the tax bill when the return was filed, then the IRS would consider your request in favor of relief. If there was any determination that financial control or domestic abuse influenced this decision, then the IRS would weigh in favor of relief. However, if either you knew or should have known about this item, or if you did not reasonably expect that your other spouse would pay the full tax bill, then the IRS would determine against relief in that situation. So when you are explaining to the IRS, make sure that you capture this point so that the IRS can determine that in your favor. Legal obligation. So if you become divorced and the divorce document states that your now ex-spouse has the sole legal obligation to pay your income tax, then the IRS would consider weighing this factor in favor of relief. It would be neutral if there was, a dual responsibility to pay the income tax. If you're still married, if you're not separated or divorced, if the divorce decree doesn't mention any obligation, those are all neutral ranking factors. And then against relief would be if you have a divorce decree that says you as the requesting spouse have the sole legal obligation, then the IRS would probably be inclined to rule against your relief request. Significant benefit. So if the IRS can determine that during this time you as the requesting spouse enjoyed significant benefits, assets, vacations, lots of discretionary spending, obviously that would indicate a significant benefit, and that would make your case for requesting relief, that would be a negative factor. If your ex-spouse controlled the household and business finances, if there's abuse involved and these expenditures happen around you due to no fault of your own, then it will be a neutral factor, as well as whether or not the amount of tax or understated tax was so small that neither spouse really received a benefit. If it's a negligible amount related to the amount of assets and everything else at hand, that's a neutral factor. In favor of relief, only if your ex-spouse significantly benefited from this while you received little to no benefit. Or if it negatively impacted you, then obviously those factors would weigh in favor of relief. Compliance with tax laws. So if you had been compliant for tax years after separation or divorce, if you remain married but you're filing separate returns and you're compliant in your separate returns, then this would be a factor in favor of relief. If you were not compliant after getting a divorce, if you remain married and you still are filing joint returns and abuse is not found to be a factor, or if you remain married, filing separate returns, but you're not in compliance with the tax laws yourself, those are all factors against relief. And then the only exception would be if your noncompliance is due to an economic situation that goes back to the economic hardship, then this would be a neutral factor. As well as if you've made good faith efforts to comply, but you weren't able to, if you remain married and you're filing joint returns after requesting relief, or if you're not compliant because of your poor economic situation, that's a double reference within the Internal Revenue Manual. And then finally, mental or physical health. If you are not in good health, then obviously that would be a factor in favor of relief. If health was not really an impact, then it would simply be a neutral factor and not considered. So those are the main considerations that the IRS will look at and evaluate when determining if equitable relief is something that they can grant to you as a requesting spouse, requesting relief under innocent spouse rules using IRS Form 8857. Thank you.